Hello, everyone. I'm Anais Berthier, the head of EU Affairs at ClientEarth, and I'm really happy to welcome you to our online conference on access to justice in environmental matters today. We would, of course, have preferred to have it in person and to be all together in the same room and to be able to have face-to-face discussions. It would have been so much nicer. But given the circumstances, we, of course, did not have any other choices, and I had to organize this event online. But it's still really good to be able to have this conference online because there are still a lot of things to be discussed and debated about access to justice in environmental matters. There are lots of initiatives, interesting decisions and discussions that are taking place at national level, but also at EU level, and we'll have the opportunity to discuss that more in detail actually in our first session this morning with our speakers, and including myself. So citizens and NGOs, associations as well, rely more and more on the courts to hold decision makers accountable and to ensure that the law, including the environmental legislation, is enforced before the court. So lots of interesting things happening and to discuss. This conference is closing project funded by the European Commission, by the LIFE program of the European Commission, and that ClientEarth has carried out with our partner, Justice and Environment, in 8 countries, and which aim was to raise awareness of judges, public interest lawyers, public authorities, NGOs, and citizens and academics about access to justice in environmental matters. And so this conference will hopefully give an overview of the state of the implementation of the right to access to justice in all these different member states and maybe beyond. And so we will have 2 sessions today and 2 sessions tomorrow. Of course, the agenda of the conference, you can find it online with the relevant timing and details to connect. So, unfortunately, Aurel, who is going to give the keynote speech, could not join us today. She had a really, really important professional commitment that came up unexpectedly. And so, yeah, we'll hear her keynote speech registered. And our colleague, we're really happy to have Adam Weiss, our colleague at ClientEarth, our head of the Oceans program, to chair the 2 sessions that we will have today. And so I hope we're going to have fruitful, interesting, and constructive discussions during these 2 next days. Adam, to you. Thank you.
Thank you, Anais. I'm very excited to be here and to help us keep to time this morning as we hear so many interesting presentations. And with that in mind, I will go ahead and introduce our recorded keynote speaker. Anya Ryle is co-director of the Centre for Law and the Environment at University College Cork in Ireland. Anya is also vice chair of the Aarhus Convention Compliance Committee. Please keep in mind that Anya is participating in the conference in her personal capacity. So we will go ahead now and hear Anya's pre-recorded keynote speech.
This conference provides us with an important opportunity to pause and to reflect on the development of the right of access to justice in environmental matters. For example, what do we count among the most impactful achievements so far? What are the most significant challenges that still remain to be resolved? And what lies ahead of us now? These questions will surface throughout the conference, and they will give a focus to how we arrange our discussion and ultimately how we work together to identify some key conclusions. I think it's important to recall at the very outset of the conference that the answers to these questions will depend very much on your own experience, on developments in the jurisdiction that you are most familiar with, and of course, the particular role that you play in your day-to-day engagement with the law, law enforcement, and environmental protection. All of us bring very different experiences and perspectives on access to justice to today's discussion. And it is that rich diversity of experience that will inform and animate the debate. It will provide the basis on which to identify best practice, to find out what works well, and to chart the best way forward in the interest of the environment and of future generations. In fact, the conference programme itself provides, I think, a very helpful outline to frame these opening remarks and to set the scene for our discussion. The 4 conference sessions highlight an excellent set of overarching themes. And so I propose to say a little about each of them in turn, to suggest some questions for your consideration, and also to identify some particular points for reflection and further discussion. So starting then with the theme of the first conference session, and that is the vital role of strategic litigation to drive legal reform at a structural level. It's clear to everyone, I think, that there has been a very significant increase in the volume of strategic litigation in recent years, and this is a positive development. The rise in strategic litigation has been driven in large part by very determined, very brave individuals and NGOs, and this trend is set to continue into the future. It's also clear that the Aarhus Convention has had and continues to have an enormous influence in driving improvements in access to justice, and particularly around issues such as standing and the cost of litigation. These improvements have enabled the emergence of even more strategic litigation, which in turn has led to an expansion of what I describe as the frontiers of access to justice. Of course, I'm not saying that access to justice at national level is perfect, far from it. There is no doubt that very significant challenges remain to be tackled, but it is important to acknowledge the driving force that is the Aarhus Convention and the related developments in European Union law and the dynamic jurisprudence of the Court of Justice in interpreting the access to justice obligations. Certainly, as regards access to justice at the national level, the Luxembourg Court has played a pivotal role in championing effective judicial protection and pushing the boundaries as regards the concept of wide access to justice, to use the phrase found in Article 9 of the Aarhus Convention. The Court has also acknowledged consistently the critical role played by individuals and NGOs in the enforcement of environmental law in the public interest. That has been a persistent hallmark of the Court's jurisprudence and a very important one. In addition to the Aarhus Convention, Article 47 of the Charter has also played a vital role in further underpinning the principle of effective judicial protection, and no doubt it will continue to do so into the future. It is interesting to observe, however, that the Aarhus Convention is now, would you believe, 22 years old. It has set important minimum standards governing access to justice in environmental matters. And of course, these minimum standards also form part of the legal order of the European Union. But when you think about it, it is striking how the process of identifying the scope and the content of these minimum standards has been such a fraught and gradual endeavour over a very significant period of years. For example, questions like how expensive is prohibitively expensive? What is the outer limit of the concept of wide access to justice? And how are these particular concepts to be applied in specific cases? Many of you participating in this conference will be very aware of how fundamental concepts that are inherent in the right of access to justice, for example, the idea of prohibitively expensive costs that I just mentioned, those concepts have had to be teased out gradually through complex, lengthy, and often expensive litigation, both at national and at European Union level. And even then, important questions still remain. For example, as regards the scope of a right to legal aid or some other form of financial assistance to facilitate access to justice, to make it real for people in particular circumstances. It's notable too that the preliminary ruling procedure has played a key role here in facilitating that absolutely essential dialogue between the Court of Justice and the national courts in identifying the scope and content of the different elements to the access to justice obligation. And here again, it's important that we recall that this ongoing dialogue between the national courts and the Court of Justice is necessary in order to take account of the wide diversity in administrative and legal systems that operate right across the 27 member states of the European Union. Putting it simply, there is no one-size-fits-all when it comes to access to justice in environmental matters. Turning then briefly to the theme of the second conference session, and this revolves around how to identify best practice across different jurisdictions in order to share successful models, and then how best to communicate and embed successful models elsewhere. And I think this theme underscores the importance of conferences and events as an effective means of sharing that knowledge, understanding, and experience. And it's not only formal conferences such as this one, but also regular informal workshops and gatherings at national, European Union, and the international level to provide important updates and analysis of the most recent developments in law and policy relating to the environment. And the point that I'm leading up to here is that it's important that funding is available to facilitate high quality, accessible events. And I believe that the universities also have a key role to play here in organising and supporting such events that are open to the public free of charge. And the theme of the second conference session also highlights, I think, the importance of large-scale innovative research projects involving multiple jurisdictions to again seek to identify how environmental laws actually operate in practice and how best to design laws and governance systems that deliver better outcomes for the environment. Is the current body of law at national and European Union level actually delivering sound environmental decision-making? Is it operating in practice to improve environmental quality? These are obviously very significant questions, and it seems to me that there is still much empirical research to be done on the actual effectiveness of our environmental laws. And I think it's notable in that regard that this conference is part of a major project funded by the LIFE programme, which is very significant. This level of frontier research and the proactive communication of the outputs of this research, including, for example, this conference, communicating the outputs of the research to policymakers, lawyers, judges, and the public is an absolutely essential element of the overall body of work to improve access to justice in environmental matters. Turning then to the theme of the third conference session, and this theme concerns promoting access rights, including, of course, the right of access to justice and the most recent developments in the jurisprudence among the public authorities, lawyers, and the judiciary, amongst others. A very significant challenge here is how to keep pace with the very rapid developments in the law and in the jurisprudence. It's very difficult for experienced lawyers like myself to keep pace with developments. So the task for the public who have no legal training is overwhelming. And I think the excellent notice on access to justice in environmental matters, which was published by the Commission in April 2017, serves to demonstrate quite dramatically how rapidly the jurisprudence has evolved and how it continues to evolve, and that this is quite a complex body of jurisprudence. And the Commission's notice, I think, provides a very helpful guide or overview as to how things are developing. And it's also important that the Commission has provided very useful updates to the text of the original notice, again, informing those who are interested about the most recent developments in the jurisprudence almost as they emerge. In addition to developments at the European Union level, it's also necessary, of course, to track developments at the international level, including the findings of the Aarhus Convention Compliance Committee and significant developments in the national courts. With these different sources of legal authority at the international level, the European Union level, and at national levels, there is, I believe, a really serious risk of what I would describe as fragmentation of a legal principle, where different approaches could be taken by, say, the Compliance Committee on the one hand, the Court of Justice on the other, and the various national jurisdictions at local level. And that risk of fragmentation poses an obvious challenge for the principle of legal certainty. And after all, the principle of legal certainty is one of the bedrocks of the rule of law. So we need to be alert to how the principles are evolving at the different levels, be it international, European Union level, and national level, to ensure again that minimum standards for access to justice are identified and that a consistent pattern of principle emerges. So I would be very interested to hear more on this fragmentation of legal principle point during this conference. Turning finally to the theme of the fourth session of the conference, and this again involves the use of strategic litigation to ensure effective implementation and enforcement of environmental laws. And here the conference organisers have sensibly selected a number of very interesting case studies, and I look forward to hearing from the lawyers who led these groundbreaking cases, and hearing especially about the wider impact of these cases and their potential to bring about lasting systemic change. The fourth session of the conference in particular will also demonstrate, it seems to me, the emergence of environmental human rights as a key strand in contemporary strategic litigation. And I also see this fourth session as being particularly important by providing inspiration for the next up-and-coming generation of environmental lawyers. This conference, with the strong focus throughout on what can be achieved by using strategic litigation, is a vital learning experience for the environmental lawyers of the future. And that's something that I think really needs to be highlighted and something for which the conference organisers deserve to be congratulated. So to conclude these opening remarks, the intention of which is very much really to set the scene for the four sessions that are to follow, I would begin by recalling that we're faced with a climate and biodiversity crisis. The global pandemic has thrown life as we know it dramatically off course. Every day we see new threats to the rule of law and to our precious democratic structures. The sharp economic impact of the pandemic has forced governments to pay attention to a rapid and intensive push for economic recovery. And as many of us will be aware from our experience, it's at times of economic crisis that we can see dangerous levels of backsliding on environmental rights and on human rights more generally. In early September, the Aarhus Convention Compliance Committee issued a public statement on the application of the Convention during the COVID-19 pandemic and the subsequent phase of economic recovery. And that statement is publicly available on the committee's website. Putting it in very simple terms, the Compliance Committee's statement confirms that the Convention rights continue to apply and that the pandemic cannot justify any restriction on those rights. The Convention rights continue to apply and the pandemic cannot justify any restriction on those rights. Given our current circumstances, the outlook for the future is uncertain. I think there's no doubt about that. But we must be very careful not to take our environmental rights for granted. We see the position of environmental human rights defenders around the world becoming increasingly fraught on an almost daily basis. And now is definitely a time for heightened vigilance and heightened resilience. I finish by saying that the right of access to justice is essential to maintaining the rule of law, to defending human rights, and to preserving and protecting the environment for present and future generations. We've come a long way, but there's still a lot to do. I look forward to lots of questions, informed discussion, and a lively conference. Thank you.
I think we get a sense of the very huge importance of the issues that we're talking about today. Let's move on to our very first session, talking about strategic litigation, which is certainly one of my favorite subjects. I will introduce each speaker one at a time. Each speaker will have 20 minutes, and then we're hoping to have an interesting discussion based on your questions. And you will see on your screen that you have the ability separately from the chat to enter questions into a question space. So please do not hesitate to do that as questions pop up. In the meantime, I will introduce the first speaker on this panel. It's an honor to introduce Onno Brouwer, who is a well-known expert in EU law. He's an outspoken advocate for transparency in EU decision-making and has brought many landmark EU transparency cases to the EU courts. And through his involvement at the law firm Freshfields, he's played a crucial role in that firm's very impressive pro bono practice. So Onno Brouwer, the floor is yours.
Adam, many thanks for this introduction. And I must emphasize it's always teamwork with the persons who are involved in these cases and who have the stamina to sometimes spend many years to work on a matter and see that we get a result which may be of some significance for the future. What I wanted to briefly mention is a few specific points, because I thought that was maybe good for our discussion also. And please let me know, Adam, if I'm close to reaching my 20 minutes, because I certainly do not want to speak longer than I should. The first element which I want to briefly discuss is the question why transparency or access to documents is so crucial for NGOs, for journalists, for academics, for MEPs, MPs, and many others. And there are a number of reasons, but the few I want to mention is first that access to information, and that's obvious, allows one to generate political debate and participate in decision making, which also tells us that access to information, access to documents must function in a way that you actually get the information or the documents in time to be able to generate political debate or develop a piece of advocacy. And what's interesting is that with the EU treaty, the Treaty of the European Union after Lisbon, a normative choice has been made in the EU that democracy does not only consist of representative democracy, which is relying on elected members of parliament, but that a cornerstone of democracy is also participation of citizens in the decision-making of the EU, and that's the participatory democracy. And that's Article 10 of the Treaty on the European Union. And that's a very important aspect, because when we look at the EU, one can say that, in fact, the EU institutions need more transparency even than institutions or authorities at the national level. Because at the national level in member states, you have legal orders with all kinds of checks and balances, political checks and balances, and legal checks and balances and proceedings, which we do not have at the level of the EU. And I think it is clearly in the interest of the EU institutions, and in the interest of the EU, if the EU as an international organization wants to survive, that it is transparent and that citizens, NGOs, and others can actually follow and understand the decision-making of the EU, and that they can also, as prescribed by the treaty, participate in the decision-making of the EU. That does, of course, not mean that nothing can be secret. When we're talking about some information like operational information to combat fraud, or operational information to combat or to terrorism, obviously those are matters where actually a certain information may need to be kept secret. But there's a lot of information and a lot of decision making which should be entirely transparent and where citizens should be able to participate. Now, environmental information is a category of its own. We know that the approach under Aarhus and also broader, and I think that becomes, we see interesting developments there, that is more and more accepted, that in the urgency we have at present with climate change and also many other urgent environmental concerns, the access to environmental information is extremely important. I thought as a second point that I should maybe just mention a few examples of why access to documents and access to information matters. By the way, I use two terms, access to information and access to documents. As we all know, at the national level, we often have access to information systems, which means that an authority must provide information and eventually even do homework to provide it. Whereas at the EU level, in a sense, unfortunately, we have an access to document system. So under the Transparency Regulation, Regulation 1049, we cannot ask an EU institution to actually go and collect information and provide it. It is an access to document system. Of course, they must go and look for the documents, but it is about documents, access to documents. Now, a few examples on how access to documents is being used to generate political debate are maybe the following. I just wanted to mention it. ClientEarth, in a case, sought access to impact assessments, which the Commission always makes when it is planning to, or when it's considering EU legislation. And those impact assessments, which are also reviewed by an impact assessment board, are very important because they tell us the internal considerations from the institution as to why it thinks it's better to have EU legislation or maybe another instrument. And this, of course, shorthand, there are other considerations, but the impact assessments tend to be published only when the EU actually adopts EU legislation, whereas very often we are very interested to know why the EU did not adopt EU legislation when actually there is a clear need for the EU to do so. And in that matter, the EU said, well, we never adopted any EU legislation, so you do not need to have access to our impact assessment. And we said, no, we're very sorry. On the contrary, we want to have access to your impact assessment, which you did make, and where we think you advocated for the adoption of EU legislation, And we want to have access to that impact assessment in order to be able to generate political debate and start a campaign or advocate for the EU legislation, which we think should be in place and which the Commission is, for some reasons, often this opposition from the Council, is not adopting. So that just is one illustration of how access to documents, in this case impact assessments, has a specific aim, a strategic aim, to advocate for the adoption of EU legislation. Another example is the access which the Swedish MEP Carl Schlyter at the time sought to an opinion from the European Commission under the Technical Norms Directive, which obliges member states to notify technical norms to the EU, so that the EU can check if these norms are compliant with EU law. And Schlyter was a member of the Green Party, at that time was on the Greens in the European Parliament, and later again in the Green Party in Sweden. But Schlyter actually had advocated for many years that the EU would adopt legislation on the declaration of the presence of nanoparticles in goods, so that people could be made aware of the presence of nanoparticles in substances and goods. But the EU had not adopted such legislation, and then actually France, as the first country in Europe, decided to adopt such legislation which prescribes the declarations of nanoparticles. And Schlyter wanted to find out why the EU gave an opinion which said that this French legislation was not compliant with EU law. And basically the EU was there with blocking the adoption of the French legislation in a situation where actually France was doing what Schlyter hoped the EU would have done. And the EU refused access to that opinion about the French law. And after quite an intense case on that matter, the access was given to the opinion of the EU Commission, which indicated why the Commission thought the French legislation was not compliant with EU law. And that is then typically a case where you can generate political debate about such national legislation, and also, again, set up an advocacy or start advocacy on, again, asking the EU to adopt legislation itself, so that it would not be just one member state dealing with the matter, but that it would actually be the EU dealing with the matter. There are, of course, many examples, and the last one which I can maybe mention, which is not in the field of the environment, but which I think is interesting, is a case where actually Access In for Europe, an NGO in Spain, brought a case or seeking access to the legal advice which the European Commission would have given on the EU-Turkey deal on immigrants. We have read a lot about this EU-Turkey deal on immigration, dealing in particular with immigrants coming from Syria. And this EU-Turkey deal had been adopted in a limbo, in a very fluid situation. And when access to documents was sought by Access In for Europe, seeking access to the legal advice of the European Commission pertaining to this EU-Turkey deal, the Commission actually responded, these are the documents we have, but there is no EU-Turkey deal because the whole arrangement concerning immigrants between the EU and Turkey has not been entered into by the EU, despite all the press releases and all the heads of state or member states claiming it was the EU who actually entered into that arrangement with Turkey. The EU said, the Commission said, well, it's not us, it's the member states. So it's very interesting that you see that access to documents can lead to two things which are very interesting. And a request for access will lead to an institution actually telling you which documents respond to your request. And then you can see what documents are there. That doesn't mean that you get them, because the institution may still say, well, these are documents, but we refuse access for these and these reasons. But at least you get a visibility on what documents are in the hands of the institutions. So what do we learn from examples like these? We learn that actually access to documents can be very crucial to generate all types of political debate and to actually get an understanding of what has or may have happened in a situation. Now that brings me to my third point or question, which is simply to say something about what progress has been made up to now with regard to the true transparency of EU institutions and agencies. Where are we today with regard to transparency? Now, obviously, the best situation would be if there would be no need to bring cases for access to documents. The best situation would be if EU institutions would actually proactively publish themselves documents that are important, which are also politically important, so that citizens can understand how the EU decision-making is working and what decisions are being taken and why they were taken and in what way they were taken, simply because documents are being published. Now that is proactive transparency. But that is, of course, not where we are. I mean, it's also a huge task, would be a huge task for EU institutions to publish everything they produce. So there is a lot of proactive transparency. There are a lot of documents are being published, and I think there real progress has been made, but there's still a real need to ask for documents which are not proactively published. And that's where the transparency regulation comes in play, and where NGOs, MEPs, and lots of people actually seek access to documents through the transparency regulation. Now, there are certain areas of EU decision-making where transparency is very difficult. This, for instance, in the area of international relations. It's very difficult to get true access, even through the transparency regulation, by seeking access to documents, to matters which are subject of, for instance, the making of international treaties. I mean, ClientEarth knows that because we brought a case, we sought access to documents pertaining to the dispute settlement mechanism in international investment protection treaties. The problem with investment treaties or investment protection treaties is that countries may actually be refraining from adopting environmental legislation because they're afraid that they will get investor claims. So there's a link between international investment protection treaties and environment, because if those treaties actually have the effect of making countries reluctant to adopt environmental legislation which is needed because they're afraid they will get investor claims, then obviously there is something wrong. But then to get access to documents pertaining to the dispute settlement mechanisms in those treaties, which mean that conflicts are being decided behind closed doors in arbitration instead of openly before courts, well, that appear to be very difficult. And we have had a number of cases in the field of international relations where we sought access to negotiation mandates or understanding what the position is of the EU in international treaties that are being concluded, entered into. That remains a very difficult field. Another difficult area is when actually it has to do with inspections which are being conducted by the EU or infringement proceedings against member states. It's still very frustrating in the sense that there's no possibility to seek access to documents which concern infringement proceedings, which the EU is planning to bring or has brought against member states for violation of EU law. There, I'm afraid, as soon as there is an investigation ongoing or an infringement proceeding running, you will not get access to documents containing to that investigation or infringement proceeding. And we are now, an example, for instance, is a case now brought regarding fishery policies, where we see that there is a lot of overfishing still in the seas, that member states have to control whether more fish, put it simply, more fish is being caught than allowed. You want to understand how inspections are being done by the authorities which should inspect that there is no violation of rules in the context of fishing. And just to get access to these type of documents is difficult because it's about auditing, it's about investigations, but yet access to those type of documents is absolutely key if one wants to set up a campaign and advocacy about the need for better controls, so that actually we could achieve a situation where the environment also in this respect is being properly protected. Now, I'm afraid I could give you many more examples where access to documents is key, and where we are still bringing cases in particular areas to make progress. An area where real progress has been made with an Emilio De Capitani case is the adoption of EU legislation itself, because as you will know, more than 80% of EU legislation is being adopted in trilogues, where, in a sense, negotiations behind closed doors between the Council, Parliament, and the Commission, and only the happy few, in a sense, the few powerful multinationals or other players would be able to input in those trilogues and follow those trilogues. And it took years to actually achieve a situation where it was accepted that there should be access to all trilogue documents, so that also NGOs, citizens, and others interested could actually see how EU legislation was being negotiated and adopted, and which would allow for, if timely access is being given, for generating political debate when EU legislation is in the making, and not only getting access to documents when EU legislation has already been finalized and adopted, which is absolutely key. So I think those are some comments I just wanted to share with you to emphasize the importance of access to documents and how access to documents is being used to generate political debate and understand how decisions are being taken. Now, that does not mean it's always easy, because there are certain trends. The EU institutions are still very often reluctant to give access or to give timely access. And that is very difficult, because one needs access to documents before decisions are being taken, not after decisions have been taken. That remains a big issue. And that in many instances we see that one seeks access to documents, and that the documents are first being refused, or just that the whole process takes so long. By the time you get the documents, there's no, it's not useful anymore to generate political debate. So that remains a real issue, this timing point. And we try and make progress in that respect, but it's not always easy. Another trend is that the EU institutions have followed quite a coordinated approach of developing or invoking general presumptions of secrecy, saying, well, these type of documents, like legal opinions, opinions from legal services, or documents which are from a pre-investigation stage or whatever, they say, well, these documents, there's a presumption that they cannot be disclosed. And then we are resisting very much the introduction of all these general presumptions of secrecy, because that's clearly not in line with the transparency regulation, which has, on the contrary, a very strong fundamental approach, which is the widest possible access. So that remains also a difficult point. The case law has accepted general presumptions in certain areas, and we are resisting the expansion of these general presumptions of secrecy, which would allow institutions to not even examine the documents document by document, but really rely on a general presumption of secrecy. Maybe just to conclude, a few practical points. I mean, I think what we see is that it is very important that NGOs and all those who consider bringing cases really think, consider carefully how they bring a case, because I think it's like always, bad cases make bad law, and we need to be very cautious, I think, with strategic legislation, that we actually think through whether what we are asking is reasonable, whether it really makes constitutional sense to ask what we ask for. And when we seek access, that we really think about it, that we only seek access to documents which we think we have very good reasons for to ask. So although the transparency regulation does not require anyone to provide reasons to ask for a document, we always say that it is important to actually think it through and only apply when you have good reasons to give, when you can give good reasons why you really need access, why it's important, so that you can also show that there is a public overriding interest or a real reason why these documents should be given, and to also not ask for too many documents at the same time, because if one wants timely access, it's much better to focus on access to the few key documents you need, rather than asking for tens or hundreds of documents. And one should also always consider whether it's really worthwhile to go to court if there's a refusal, or whether one would rather go to the Ombudsman. The European Ombudsman can deal with a practice of mismanagement or maladministration. The courts can only annul a decision. So one also needs to be very careful when there is a refusal decision. What do I do with a refusal decision? Is it worthwhile going to court and have this decision being reviewed by the court, and the court can only annul it? Or is it worthwhile to go to the European Ombudsman, who can also look from a different perspective and see if actually the EU institution has a form of maladministration by not keeping minutes, by not actually having a register which is properly kept, and others. So those are the two solutions one has if you have a refusal decision: either go to court or to the Ombudsman. And I think there are different routes, and they need to be carefully considered. So those are just a few practical points. But I just want to indicate that there is still a lot to do in this area. That yes, progress has been made, and I think it's very crucial that we keep transparency on the agenda and make use of it, because it's crucial to make progress in many areas of EU decision making, including, of course, the environment. Thank you very much.
Thank you so much, Onno, for that very interesting overview. And we've already had a few questions, which makes me very happy, and including one that our colleague Anne Friel has already answered. But before we move to the question and answer, I'll give the other speakers a chance to give us their ideas. And I'm very happy to present our next speaker, who is with us from the European Commission. Aurel Ciobanu-Dordea is Director of the Directorate for Implementation and Support to the Member States, and that's within DG Environment. And he has been in this position since January 2014. He is in charge, among other things, of the enforcement of EU environmental laws, and he is in charge of the EU's participation and guaranteeing that the EU lives up to its obligations under the Aarhus Convention. Aurel, the floor is yours for 20 minutes.
Thank you very much. Good morning, everybody. I hope you can hear me well. I would say it's a privilege to participate in this conference as a speaker. And I would like to thank the organizers for extending this invitation to me on behalf, of course, of my colleagues in the European Commission who work in this area. It's a privilege from several perspectives because this is, I understand, the closing conference of a project funded by the LIFE program on access to justice for a greener Europe. And this means it's the closing event of a long time effort of the NGOs to work in a way in support of our work in the European Commission, to work in order to improve access to justice in the national courts in environmental matters. So it's an opportunity for me to thank those who have worked, the NGOs and the persons who have worked on this project in a way on a shared agenda. The improvement of judicial oversight in environmental matters. It's also a privilege for me because it offers me the possibility to have an insight into the way of thinking of strategic litigants, ClientEarth and many others, the law offices Onno works for and who are world famous for their activities in general. And I had the opportunity to look into the lion's belly when I was hearing him talking about what is a priority, what is not a priority, what is critical. But I don't want to be to make fun of this. It was very important what he said, and it clarified a little bit more for me what are the concerns, and indeed he has pointed to a large number of legitimate interests from the public opinion, not just from the non-governmental organizations world, but from the wider world of the public opinion. And of course, here I would say I'm on the other side of the line, and I have recognized a number of pathologies, of course, in what he said, the pathologies of the European Commission. I have recognized also a number of concerns that we have, but my purpose is not to provide an answer to him, although I can elaborate on these, and I would be happy to exchange more with him and with the NGO colleagues on these topics in the near future. And I'm not saying this to kick the ball in the long grass. It would be really interesting to exchange beyond this conference. It's an opportunity for me to participate here also for a third reason, and maybe I apologize. I don't want to sound, how to say, to diminish the importance of the other elements that I have stressed already, but the most important opportunity is to, how to say, to present to you in a way, I mean, to raise your awareness of the fact that the European Commission has made yesterday an important step forward in furthering the compliance of the European Union with the obligations under the Aarhus Convention in terms of access to justice in environmental matters by adopting a legislative proposal for the revision of the access of the Aarhus regulation, and by adopting also a communication which addresses more the national leg of the problem of access to justice, while the legislative proposal addresses the European Union leg and the European Union level of action. The communication sends a number of signals to the member states about what are the priorities in terms of improving access to justice at the national level. And I was saying that this is maybe the most important reason for me to be here today. I will explain this a little bit in the light, or by drawing your attention to the major openings that the Commission has proposed to operate with the legislative proposal. First of all, because we hugely expand the types of non-legislative acts which will be open in the future if this proposal is adopted by the Parliament and by the Council, which will be exposed in the future to, which will be open in the future to administrative review by the environmental, non-governmental organizations. So we go beyond the individual acts that are currently open to such an administrative review, and we propose to subject to administrative review also the regulatory acts. This is a pearl of the crown, to put it in a very simple way, because the regulatory acts, namely acts which are adopted by the Union institutions and primarily by the Commission, but not just by the Commission. In some areas, the Council also has powers in this respect, are executing the European Union legislation. And the execution of and implementation of Union legislation is of crucial importance. And the second important opening that the Commission is operating when proposing or proposes to operate through this legislative proposal is to expand the number of areas the acts subject to review cover. Currently, only individual acts are acts of individual scope, as the theory goes, or the formal language goes, adopted essentially in the area of environment, are subject to administrative review. If our proposal is adopted by the Parliament and the Council, also acts in other areas which may have negative consequences on the environmental protection will be open to administrative review. And you will, some may say, oh, bah, what is this administrative review and why so important? It is important because it holds the Commission accountable on consistency matters. Is the Commission or is the Council, are they consistent with the legislation when they adopt regulatory acts in the area of agricultural policy, for instance, or in the area of energy, also in the area of environment, based on the environmental legal basis? Are we consistent with the legislation which is adopted and which is very ambitious, adopted by the co-legislators? And it's also very important because the administrative review, if it leads to an unsatisfactory result, allows the NGO to go in front of the General Court of the European Union in order to challenge the way in which the Commission has managed the administrative review. And while some will say, oh, this is mainly procedural, it has the judicial review of the Commission decision in response to the administrative review has an indirect impact also on the substantive aspects, because form and content are related. Procedure and content and substance are closely interwoven. I would like to say a few words also about the communication which has been adopted by the Commission, because it is important to look at the European Union as it really is, namely a system of multi-level governance, where legislation is adopted at the level of the European Union, and some implementing regulations are adopted also at the level of the European Union, but the execution, the practical implementation, goes in the member states. So how the European Union level authorizations of chemical substances, of pesticides, is implemented in practice matters, and what effectively happens with those EU-level authorizations, how they are operated in the real life. And here lies also the opportunity. The judicial review of the execution or of the implementation of acts adopted at EU level matters in a multi-level system of governance. And this is why the communication is important, because we would like to be perceived like this. It sends an electric signal to the, or electrifying signal to the member states that a number of things must change in respect of the access to justice in their national courts. There are still too many obstacles for the NGOs to be able or restricting their possibility to review how the implementation of European level acts happens in practice. And why is this important, such a control, such an oversight through the national courts? Because there is this system of preliminary rulings, of requests for preliminary rulings that the national courts can address to the Court of Justice of the European Union, and which connect the national level implementation with the European level regulation or legislation. And the Court of Justice of the European Union has the opportunity to provide a European-wide response to such challenges, bringing the situation from a tiny court in the most distant corner of Malta or of Finland or Romania or Portugal to the attention of everybody. And this matters in particular when NGOs want to challenge the legality of regulatory acts or of implementing acts adopted at the level of the European Union. To challenge that a certain authorization or a certain regulatory act which requires national implementing measures is illegal in the light of a directive or of a regulation adopted by the co-legislators. In those situations, only the Court of Justice of the European Union can say yes or no, yes, it's illegal, or no, it's not illegal. But it shows also the power which is given to the NGOs through such an access to justice in national courts, in environmental matters covered by EU law. And in the communication, we indicate to the member states that there are 4 priorities we encourage them to look into, 4 main shortcomings that we have identified horizontally, looking at the big picture across the European Union. Of course, we have details about the situation in more or less each member state. And we are sending also the signal that if we will not see a remediation by the member states of the situation under these 4 priorities, the Commission will act in its capacity as guardian of the treaties. So the much hated by some and the very popular in the eyes of others, we will make use of the infringement procedures. So this is very important. And I would like now, if I may, and I still have time, and I still have the benefit of your attention, I would like now to try to address, in the light of these elements which I have highlighted from the important package, legislative proposal and communication adopted yesterday by the College of Commissioners, to try to address the dilemma or the challenge which has been highlighted by the organizers in the short text displayed on the website of the conference about the Plowman test. Is the Plowman test still relevant today? Such an undemocratic and, how to say, illegitimate way of thinking from the Court of Justice, coined 50 years ago, or it was in the middle of the 60s, I lost counting the decades. I'm as old as the Plowman test, more or less, or as young as the Plowman test. So is this still relevant? And do we NGOs have the same privileges of accessing the Court of Justice of the European Union like the industry has? Because we are competing with the industry. And I would like to say maybe 2 or 3 things. That the Plowman test is in a way a false target, that the legislative proposal adopted yesterday by the European Commission gives the environmental NGOs rights which are not possessed by the industry, and the situation of the environmental NGOs is more or less, grosso modo speaking, becoming more comparable with the rights of industry, which are not unlimited. They are limited only to challenge regulatory acts of direct concern for them. Yeah. While the administrative review we are opening up through the legislative proposal goes beyond this. And I am also trying to say that the Plowman test is also, or the so-called paradigm of the Plowman test is directing the attention in a way in the wrong direction, at the wrong point. The real point and the real prize is in the access to justice to national courts. I am not saying that the challenges and the activity of the NGOs at EU level, the administrative reviews, the scrutiny of how the Commission is exercising its regulatory powers at levels below the European legislation doesn't matter. It matters. But I posit, I sustain that there are 2 vectors for strategic litigation. And none of these 2 vectors include the destruction or the reformation of the Plowman test. The 2 vectors are at EU level, make use of the hugely expanded opportunities for administrative review, and bring cases in front of the Court of Justice if you are not satisfied by the answers that the Commission will provide in response to the request for administrative review. And the second one, and it's not a peripheral one, it's not a minor one, it's not an exotic one, but it is a very important one. Use the opportunities and use strategic litigation indeed in order to make use of the checks and balances over the regulatory activity of the European Union, but also in order to break the ice or to open the holes in the ice in the limitations existing currently in national courts in front of the NGOs and individuals' rights of access to justice. And why is the Plowman test not the right target? I wouldn't say even that it's a false target. It's not the right target, and I don't want to be polemic. I'm not saying this because it's a 50 years old judicial philosophy which has been developed by the Court of Justice, which many have tried to reverse, and they have all failed. The fact that all have failed in 50 years is not an argument for not trying once more, but because it is a judicial philosophy which was developed in the framework of the treaty and in compliance with the treaty, transposing in more practical terms the provisions still existing in the Treaty on the Functioning of the European Union. It is a legitimate doctrine in the light of the treaties. So the first question we need to answer is whether reversing the Plowman doctrine, which entails the revision of the treaties, is a realistic goal that is in our powers. And the other question is to ask in this context, and in the light of the paragraph that you have displayed on the website of the conference, is you want to dislodge something. What do you put in place of the dislodged philosophy? Some preach a wide access of individuals, not just of NGOs and not just of environmental NGOs. Some have already asked, why not consumer organizations? Why not individuals? Is this a realistic way of thinking in a union which still has, even after the departure of the United Kingdom, has 420 million of inhabitants? How do you differentiate with them? In terms of environmental rights and interests for environmental matters, where do you draw the distinction line between among the 420 million inhabitants? And this is realistic for a top court at the top of the food chain of the EU legal order. The Plowman Doctrine was created by the Court of Justice in order to be able to perform its key function as an orientation court, not as a court that would review the nitty-gritty of the litigation across the European Union. It must remain a strategic court. It must be able to deal with infringement procedures, with the preliminary rulings, to keep the unity of EU law, to preserve its capacity to guide the national courts in implementing and contributing to the execution of EU law across a union of 420 million citizens, and you don't know how many legal persons in a vivid union which develops permanently. So It is, I would say even, but my point is not to defend the thinking of the Court of Justice, but I would say that we need to bear in mind the fact that this is also a doctrine which was inspired by realism in the light of the tasks and functions which the treaties have attributed to the Court of Justice of the European Union. In the light of this, I advocate once again, and I would like this to be the takeaway of the discussion today. It is more realistic and pragmatic. Pragmatic doesn't mean ideologically neutral and doesn't mean asexuated, but pragmatic means indeed realistic, to adapt our action, our targets, and also our strategic litigation to the concrete realities, political and legal, of the present-day European Union, and to make use at the maximum, for instance, of the opportunities which are offered by the revision of the Aarhus regulation. And I think the Commission was able to offer concretely not a solution that would just pay lip service to the Aarhus Convention, but a concrete solution, a concrete platform also for the development of the strategic litigation of the environmental non-governmental organizations. I would stop here. I apologize if I might have been too long.
Thank you, Aurel, for that very provocative and inspiring perspective on access to justice, particularly before the Court of Justice. And I think we're all very excited about yesterday's developments, which really give this conference a feeling of being in the current moment. We'll move on now to our third and final speaker, who it's a great pleasure for me to introduce because this is my colleague, Anais Berthier. Anais is a senior lawyer at ClientEarth. She recently became our head of EU affairs. But before that, she was leading our environmental democracy program as its head. Her work there in that program focused on ensuring the implementation and enforcement of the Aarhus Convention, which, as you all know, is about access to information, public participation, and access to justice. Anais, the floor is yours for 20 minutes.
Thanks, Adam. Well, I think I'd like to start by saying that it's clear that the context we are in today, in relation to the place that the environment has in everybody's life, into the people's life, has considerably changed over the recent years. The public, the young people, the associations, the NGOs have played an increasing active role in putting pressure on decision makers at national, EU, international level for them to enforce environmental legislation and to adopt stronger environmental standards. And they've succeeded partly. The environment has never been so high up in the political agenda. We see it with the adoption of the European Green Deal that is very welcome from the European Commission. Never before the environment had been so high up actually in the political agenda of the European Commission. So that's really a very positive change. Civil society members so have the right to demonstrate in the streets, of course, and that's welcome. But part of the population, I'm not asking for an actio popularis, should also be provided with rights, with procedural rights. And among these procedural rights, with the right to go to court, both to make decision makers accountable, but also to enforce the law, including environmental legislation. And so I cannot resist to quote the famous sentence from Advocate-General Charleston, that the natural environment belongs to us all, and its protection is our collective responsibility. The court has recognized that the rules of EU environmental law, for the most part, address the public interest, and not merely the protection of the interests of individuals as such. And neither water nor the fish swimming in it can go to court, and trees likewise have no legal standing. And so as such, NGOs, environmental NGOs, are often the best place to represent and to defend this environment before the court, whether it is at national level or at EU level. And so it's clearer today, even more today, and it's getting clearer and clearer actually, that access to justice is part of the solution to the environmental crisis we are living today. Providing access to justice to the members of the public, both at national level and at EU level, is key to the success of the EU Green Deal and to achieving the green transition that I hope we all here today want to see happen. We won't succeed in delivering the changes we need without providing the proper level of access to courts to the members of the public, and to ensure that this public gets even more actively involved in this process to ensure better implementation and enforcement of the law. That is crucial. Then I'd like to say a few words on the state of the implementation of the access rights at EU level, and then a few words at national level. So the EU has ratified the Aarhus Convention in 2005. It is a party to the Aarhus Convention, just as any other member state is a party to the Aarhus Convention. And as such, there is no legal or political justification to actually treat the EU and its institution differently from the public authorities of the member states, which are also subject to the provisions of the Aarhus Convention, including on access to justice. According to the treaty, all the provisions of the international conventions are binding upon all the European institutions, including the Court of Justice of the EU, which is, of course, one of the European institutions. And so the Court is bound by the provisions of the Aarhus Convention. And I also speak about this famous Lohmann test that has been adopted in, I think, 1962. So it's more than 60 years that the court has reasserted over and over again exactly the same jurisprudence that I must explain a bit more for those who are not that familiar with what it means. According to the Lohmann test, so in which the court has interpreted the conditions that we must fulfill to have standing before the court, according to Article 263, paragraph 4, the applicant needs to be directly and individually concerned in most of the case, or only directly concerned. And the court has adopted the individual concern criteria in a very, very restrictive way. In a way that means that to have standing, an individual or an NGO should be the only one in the world to be impacted by the decision it seeks to challenge before the court. And so it's easy to understand that in environmental matters, decisions adopted by the European institutions will never impact only one person or only one NGO. It will impact at least 100,000 millions of people. And so according to this Lohmann test, we found ourselves in a kind of paradoxical situation, since the more people are impacted by decisions that has been adopted by a European institution, the less chances we have to have legal standing before the court to challenge that decision. And so that's how big the democratic deficit is still at EU level, because no NGO or no individual ever have been provided legal standing to challenge any decisions adopted by a European institutions before the Court of Justice of the EU under the treaty. So that's how big the democratic deficit. So we think, and we're not the only one, to think that the jurisprudence of the court should evolve. The Aarhus Convention Compliance Committee, in our case against the EU, that has led to the revision of the Aarhus regulation, that is very welcome, has also found that the Lohmann test and the interpretation of the court is in breach with the Aarhus Convention, and that it is a question of interpretation of the treaty, that the treaty doesn't need to be amended for the situation to change, that the court could very well actually change its interpretation, and that it should actually, because it is in breach with the access to justice provisions of the Aarhus Convention. And it's interesting to see that recently we can feel that there are some maybe different streams even within the Court of Justice of the EU, with the adoption of the opinion of the Advocate-General Bobek, which is a very positive opinion, and himself wonders why sometimes the court tries so hard to prevent certain stakeholders to have legal standing before the court to challenge certain decision, with sometimes some surprising and not that legally sound reasoning from the court itself. And that's in the Brussels region case, in which the General Court refused legal standing to the Brussels region. And so we hope that the court will follow the opinion of Advocate General Bobek. But just to say that apparently even within the court, and that's fortunately, I think it's reassuring to see that certain judges and certain Advocate General would maybe be ready to push or to change or to ensure that the jurisprudence of the court evolve on that front. So I think that the Ploman test has been adopted in 1962, 63. It's been said 60 years ago. It's not a reason, Aurel, you said it, not to change it. But I think the jurisprudence of the court should enter the 21st century. We are in 2020. And I think that the jurisprudence of the court should reflect the needs that civil society has, that we all have, and in relation as well to interpretation of the law and to the role that the law plays and to the role that the judges play. And they are playing more and more an important role because strategic litigation initiated by NGOs and citizens increase. And so the role of the judges are becoming even more important and crucial, and we also rely on them when public authorities fail to ensure the correct implementation of environmental legislation. And as well, you touched upon it as well, it should also address the imbalance there still is. And here I agree with you, but not entirely. There is still an imbalance, a real imbalance between the access that the industry has to the Court of Justice of the EU in challenging the decisions of the European institutions to protect their financial and economic interests. That's only natural. A company will protect its financial and economic interest. And they do have, to a certain extent, legal standing to challenge these decisions, way more than the NGOs ever had until now, and maybe until the Aarhus regulation is revised. But even once the Aarhus regulation will be revised, there is still something that we cannot do and that the industry may do, is to challenge actually the initial decision that are adopted by the European institutions. The industry representative, when they are directly and individually concerned, as interpreted by the court, may directly challenge the original decisions that are adopted by the European institutions. That is still something that the revision of the Aarhus regulation does not address. We can only challenge under the Aarhus regulation the reply of the European institutions to our request for an internal review of the decision of the European institutions. That's a really significant difference, because depending on the situation and depending on the case we're in, the original decision may remain in place from time to time. And a lot of discretion will be given to the European institution, even when the reply of the institution will be annulled by the court. So we still think, and we still hope, we're an NGO, we need to hope, that, and I think it's really feasible, that the jurisprudence of the court evolves, because judges also need to understand the society they live in. And we often say that citizens feel remote from the EU and its institutions. But we can understand why. First of all, it's really complicated to understand all the intricacies of the way the European institutions function, but also the fact, that's an example, the fact that NGOs and civil society haven't had access to the court since the EC has been set up also explain partly this feeling from the citizens of this remoteness from the European institutions. On the ARIS regulation now that applies the convention to the European institutions, we really welcome the decision of the European Commission to adopt regulation to revise the ARIS regulation. It is truly a very important step. It was a long-awaited decision, but we are really welcome the fact that finally the European Commission has decided to proceed to the revision of the ARIS regulation. As Aurel said it will allow NGOs to challenge non-legislative acts. And so we hopefully at the end of the process will have got rid of the individual scope criteria, which was the main obstacles for the NGOs to challenge decisions adopted by the European institutions and agencies. Most of the requests for internal reviews were rejected by the European institutions as being inadmissible because most of the decisions were not considered as being as of individual scope. And so really to get rid of this criteria is very important and should enable the NGOs to challenge way more decisions. However, because there isn't a however, unfortunately, the proposal of the European Commission doesn't go far enough. And it actually adds a new limitation to the acts that NGOs will have the right to challenge through the administrative request and before the court. And that is the fact that will be, according to the proposal of the Commission, if it's not amended through the legislative process, only able to challenge acts, non-legislative acts, which do not entail implementing measures. And that is nowhere to be found in the ARIS Convention. The ARIS Convention speaks of all acts and omissions. And so that is a new limitation that is, according to us and according to the ARIS Convention Compliance Committee, not consistent with the ARIS Convention. And I would like to recall that the ARIS regulation had also been found in violation of the ARIS Convention. So that is still not in line with the ARIS Convention, but there are other issues, other reasons why. It creates legal uncertainty as to what acts are going to entail implementing measures or not. And so the risk is that we will have to go to court just to clarify that point, just to know what acts entail implementing measures or not. And actually, there's already a bulk of case law just interpreting and trying to understand when an EU act entails implementing measures. And so, which means that it's going to delay the whole process, create even more litigation without really allowing the NGOs to challenge the original decisions that we would like to be able to challenge. The other very problematic issue with that wording is that the rationale behind this proposal is that when there are implementing measures, NGOs should challenge them at national level. And if they want to challenge the legality of the EU Act, they must do so through the referral for preliminary ruling procedure. First of all, the referral for preliminary ruling procedure is very welcome, is very useful. Most of the case law of the court in environmental matters and on access to justice originates from preliminary ruling made from national courts. So we, of course, welcome the existence of that procedure. However, it's also been considered by the Compliance Committee as not complying with the Aarhus Convention. It is not direct access to the court. And so for the purpose of the Aarhus Convention, it's still not access to justice. Also, from a more pragmatic point of view, it's really difficult to have a national court put a question to the Court of Justice of the EU. First of all, we need to have legal standing, which is not the case in all the member states. There are issues with the scope of judicial review in certain member states. There are still jurisdictions that adopts ruling in breach of the case law of the Court of Justice of the EU. There are still lots of jurisdictions that are not willing, unfortunately, to put questions to the Court of Justice of the EU. So even if we, of course, even use that procedure, ClientEarth has put questions to the court through that procedure under Article 267. So we clearly do understand the usefulness and even use it. But as a matter of access to the Court of Justice for NGOs, in accordance with the Aarhus Convention, this procedure is not in compliance with the Aarhus Convention. We would have liked also to see in that proposal to get rid of something else, to get rid of an exemption that provides that decisions in relation to state aids do not fall under the scope of the Aarhus regulation. And today, I mean, given the importance of state aid decisions in environmental matters, we don't see really the justification of preventing NGOs from challenging such decisions, which have huge impact on the environment at national level before the court. We would have also liked to see a provision on the cost that access to the court implies for NGOs. That is a very crucial issue for us. And especially since there is a trend that we observed in front of the Court of Justice of the EU to condemn the NGOs to pay the cost of the opposing party when we lose, but not only the cost of the opposing party, but also of the interveners. And so there's the Greenpeace case, for example, where, I don't know, lots of companies intervened, around 10 companies or something like that. And Greenpeace has been condemned to pay the cost of all the interveners. That, of course, you will understand, can act as a deterrent for NGOs to go to court because we don't necessarily have the funding, have the money to pay this cost. So again, we welcome the decision of the European Commission. Is truly a very important step in the right direction, but we hope that the points that I've raised will be addressed within the legislative process by the European Parliament and by the Council. I'd like to say just a few words on access to justice at national level. I won't be too long because access to justice at national level will really be tackled in the other sessions of this conference. But just to add that the lack of a directive on access to justice in environmental matters really contributes to enable certain jurisdictions to still prevent NGOs from having access to national courts in breach of the case law of the Court of Justice of the EU. And so the lack of a directive still results in lots of discrepancies on the way access to justice is provided across the EU in the 27 member states, and in letting certain obstacles, hurdles on legal standing, scope of review, not addressed, or only addressed by the Commission itself through infringement proceedings. And we welcome as well, of course, that very important role of the European Commission, which is sometimes our only remedy, our only route really to act on these jurisdictions that do not comply with the Aarhus Convention. But had we had a directive, the European Commission would not as well waste, it's not the right word, but waste capacity in these infringement proceedings, maybe because maybe the member states would comply with such a directive. We also really welcome all the efforts of the European Commission to push for more access to justice at national level. And we welcome the adoption of the communication that has been adopted yesterday along the revision of the Irish regulation. Really, we welcome it. Unfortunately, a non-legally binding instrument will never be as strong or be as convincing as a legally binding instrument such as a directive and put the pressure we need at national level. Thank you. Adam, to you. Have we lost Adam?
Only temporarily, I suspect. So maybe somebody can volunteer as a moderator. I can volunteer as a moderator. I have an interest.
Sorry about
offer
that.
myself a couple of minutes to respond to you, Anais. No, here is Adam.
Sorry about that. I seem to have had a technical glitch, but I'm back with you now, and I hope I will stay with you. Thank you so much, Anais, for making that very strong argument that the EU needs to do better in certain ways, and particularly the argument that we need to bring the jurisprudence into the 21st century. As your colleague, of course, I can only agree with you, but perhaps I'm a bit biased in that respect. We have some very interesting questions from our audience members. I think what makes the most sense is if I put a few questions at a time together and give the speakers a chance to address them. The first one, I think, is for Onno. The question is, what is the position in relation to information withheld from the public by government authorities on the basis that it is commercially sensitive to a private business developer? This question of commercially sensitive information perhaps is a third item on your list of some tricky areas, but it would be very interesting to hear you address it. There are two questions about that are related to France in particular that we have. One, I think, is also for you, Onno. It's a question about an infringement procedure that's ongoing against France that concerns the process for accessing environmental information. And the question is whether EU legislation could hinder this questioner getting access to information about the internal measures. I think the answer is probably fairly clear from what you said, Onno, but there's an irony here, I suppose, which is that the person cannot get access to information about infringement proceedings, about access to information. So perhaps just worth highlighting. And the same questioner also has a question for Aurel, which is a problem about the French national courts making references to the Court of Justice for preliminary rulings, and is asking whether the Commission is aware of this problem. And perhaps it's not just about France. There are other member states, certainly, where it's difficult to secure references. And how does the Commission deal with that, which obviously poses a blockage to the system of multi-level governance, Aurel, that you were speaking about. So perhaps, Onno, I'll point to you first on this.
Thank you. May I, before responding to these two questions, just make one comment on, because I think that the presentations of Aurel and Anais are both extremely clear and excellent, and it just triggers for me one comment I want to make, which I think is that what we are confronted with, I think, is that in the grander scheme of things, is that politics are short-term, because politicians always mind about the next election. Whereas NGOs and citizens, many of them are, so the NGOs have this, particularly in the environment, have a long-term view. And I think what we are confronted with is that we are reaching, in a sense, the limits of representative democracy, or at least what representative democracy can do to protect the planet and to protect the environment. And that's why I think we have such an urgency to have more access to justice, not only at the national level in many places, but also at the EU level. And I think that's why the Plowman test needs to be revised and will not open the floodgates to the Court of Justice, because the case will go first to the General Court, who was actually created with a lot of money to deal with. But I think we have a strange judicial architecture. It's very good there is more academic debate and more debate in general, because we have an antiquated EU system where actually the member states have privileged access to the EU court and citizens and NGOs have not. You're confronted with the Plowman test. So I think there is a real need for more access, and you can summarize it also with I can also mention another example, the agenda case, which is so important. Isn't it a pity that in 2020, there's no possibility whatsoever to bring an agenda case or a case of that type before the EU courts, because there's no standing. There's no. So I think that there is a lot to do in that respect. I just want to make that comment because it's in the grander scheme of things that we have a real problem, and why access to justice is so important, and why it needs to be really looked into and developed further. Now, I come to my question. Sorry for making this comment, but I just wanted to make this comment. I think that with the access to documents, yes, indeed. When a refusal is based when a refusal is justified by saying, well, actually what you're asking is business confidential, it obviously creates a problem, and we have seen that in areas, also in pesticides and others. But I think that there are two solutions. First of all, what is business confidential is in a sense limited in time. I mean, if something is old or partially in the public domain, etc., you can have a debate about it. And also you can, in many ways, give partial access, that you then, there's an obligation to redact what is then confidential, but give the remainder. And that brings us to Article 4.6 of the Transparency Regulation. There is a duty to consider whether partial access can be given to documents. And unfortunately, we often see that in some instances it is done very carefully, but in other instances we see that actually the institution or agency doesn't just find it a lot of hassle to redact. But it is crucially important to be aware of the fact that if not total access can be given to a document, that there's still a duty to consider whether partial access can be granted. On the infringement proceedings, yes, it's ironic that you cannot have access to documents pertaining to access legislation in a sense, or French legislation, which is subject to infringement proceedings of the EU. If I understand the question correctly, I think that the general take on this is that infringement proceedings are of an investigative nature and must remain a debate between a member state and the Commission acting as guardian of the treaty, bringing an action against the member state. What is unfortunate, of course, is that everybody could win if you could have a kind of amicus curiae submissions or debate about what's happening or what the situation actually is. But we are in a situation where sometimes even the existence of infringement proceedings is kept secret, or those proceedings being brought. Whereas I think it would be beneficial for both institutions and for NGOs if there could be more transparency around this. my experience is that often you can get more at the national level. You may be able to get more access about to documents or information about infringement proceedings at the national level. So there are ways to still get information or documents, but at the EU level, it's not easy. Thank you.
Thank you, Onno. I wonder, Aurel, if you have any thoughts about this issue in relation to France in particular, or any member state, about the difficulty of securing references to the Court of Justice from the national court.
Yes, I would like, however, to benefit from the privileges of being a member of such a learned panel and be able to make 3 brief comments in return to Anais, because she was the last speaker. 3 brief comments. Anais, please do not lose from sight the fact that what the Aarhus Convention requires the parties to provide in order to be in compliance with it is administrative or judicial review. This is a fundamental aspect. Yes. Second comment would be, it is, how to say, it is building on a joke, which is so much applicable to the European Commission as it is to other players, including the environmental NGOs. The joke is a very brief one and is a very banal one. People holding hammers in their hands tend to see only nails around them. So EU-level players, be it the European Commission, be it environmental NGOs, tend to think that the solution to the problems they see can be only at European level. For instance, only in the Court of Justice of the European Union. It's not true. And why I'm making this joke? Because you made a comment about the serious limitation that the proposal would introduce with one hand in return of the advances which it has provided with the other hand. So in a way, the Commission is taking back with the left what it has offered with the right. The implementing measures, the provisions requiring implementing measures are not insulated from judicial review. Only the judicial review can be thought at the level where the implementing measures are taken. If the implementing measures at EU are taken at EU level, they can be challenged at EU level. If they are taken at national level, they can be challenged at national level. And it makes total practical sense, not just legal sense, also practical sense, to go where the decision is being made, because there the picture is crystal clear. And the third brief comment I would make, you referred to the communication on access to justice by saying that, oh, but the communication will never replace a legislation. It is not meant to replace a legislation. And I will say very briefly, and I can explain, but not now, a little bit later, if there is an interest for this and time for this, that we don't need a directive on access to justice in environmental matters in national courts, because in 10 years, the Court of Justice went so far in clarifying the implications of rights of access to justice in national courts in environmental matters, that the Commission doesn't need to bring forward the legislative proposal, and the co-legislator don't need to. We can build everything on the case law of the Court of Justice of the European Union. So the communication is only the sound that precedes the aircraft which moves to ultrasonic speed. You have heard the sound, and in a few seconds you will see the action of the European Commission in infringement procedures. And now I'm coming on infringement procedures and on preliminary questions to the question raised by Adam. Yes, we are aware that, to put it like this, the French courts are scarcer users of preliminary ruling requests. But France is not the only one, indeed, in this position. And how do we judge what is scarce use or what is rich use? Do we look at the numbers, or what's the benchmark? And I would say the benchmark is not a quantitative one. It must be a qualitative one. The qualitative one is the following one. How much divergence in the interpretation of the European law takes place in French courts in the absence of a frequent use of the preliminary rulings procedure? How many acts of EU law have been unduly declared void by the French courts? How many interpretations have been at odds with the interpretation of the Court of Justice of the European Union? And certainly the person who has asked the question has also heard about the théorie de l'acte clair, ou éclairé, which has been developed by the Court of Justice of the European Union in order to allow the national courts not to ask questions when the answer is obvious. Even if there is a problem of European Union law in front of the national judge, he doesn't or she doesn't need to ask questions if it's clear from the circumstances and from the provisions of the Act what the answer is, or he or she can build on prior interpretations issued by the Court of Justice in other cases. So I would say that, to my knowledge, but I only know a bit about environmental law and very, very little about a few other areas of European law, I haven't seen any such a significant divergence from the French court. So I don't see a French crisis. Thank you.
Thank you so much for that. I will move on to ask two more of the questions that came up, and we've got about 6 minutes or so left. One question that came up, and I think this relates to some of the things you were just saying, Aurel, about implementing measures. Is there a route for NGOs to challenge the validity of acts with no implementing measures? And there was also a question that came up about the net gain principle. The EU advocates the net gain principle in various policy documents, for example, the Biodiversity Strategy and the Circular Economy Action Plan. And the question is whether the EU's access to justice systems are fit for purpose to implement this principle within the European Union. So those are two questions, and I'll leave them for anyone to respond. I should just say that Anais is still with us. She's just in the ClientEarth team computer. And I'll also just mention a comment that was put in, which I think relates to this discussion that we've been having about the Plowman test and the need for access to justice to evolve. The comment was whether if we wanted greater access to justice, why did the member states not revise Article 263, paragraph 4 in a different way in the Lisbon Treaty? I think that's more of a rhetorical point. So I would open it to anyone who would like to answer at this point. If no one pipes up, then I might point to you in particular, Aurel, because of the implementing. It follows well into something that you were just saying. Oh, Anais, please.
Hi, it's Anais. Sorry, still technological problem. I hope you can at least hear me. Yeah, well, it's good to see that we still have some disagreement with the European Commission, because otherwise, I mean, you know, it would be too simple, and
the life would become dull.
And so, yeah, I must say I'm a bit surprised at the fact that you say that so clearly that an access to justice directive is not necessary. because in 2003, the European Commission thought it was necessary. I know it was a long time ago, and put up a proposal, a legislative proposal on the table. Unfortunately, it got stalled within the Council. So the lack of political willingness was more on the side of the Council. And I would have thought that the Commission would still be in favor of adopting such a directive, because of course it is, of course, the case law of the Court of Justice has increased and developed a lot. I agree with you on that. But the fact that there is case law on a certain matter shouldn't prevent the adoption of legislation. Legislation is also there to create the legal certainty we need. The case law of the court doesn't address all the issues that needs to be addressed in relation to access to justice in environmental matters. And this case law is still not always complied with by the national authorities, including national jurisdiction. So to me, the existence of case law on the matter does not and should not prevent the adoption of legislation, especially since all the issues are not addressed by that case law, but also because there are discussions that are ongoing at national level, and to push for even more ambitious reforms. So for example, I was in Paris speaking at the conference last week, and the Ministry of Justice and of the Environment have adopted a report proposing to reform the access to justice system in environmental matter, to propose to have specialized judges, specific référés in environmental matters, etc. Very interesting proposals. And so a piece of legislation could also envisage to push for more ambitious system and procedures in relation to access to justice in environmental matters at national level. But let's agree to disagree today. In relation to France and the refusal from the Conseil d'État often to put referral for preliminary ruling on before the Court of Justice of the EU, it's true that we hear from the French NGOs that it is an issue. And actually, the Court of Justice of the EU itself condemned France for not putting a question to the Court of Justice of the EU not so long ago, 2 years ago, I think, not in environmental matters, but in tax matters. And so we can see that even the court has to tackle the issue. And actually, we will maybe also need to try and have more of these kind of decisions from the Court of Justice of the EU against national jurisdictions, against the states where these national jurisdictions are, and that refuse just because they think the act is clear, but we don't agree, and therefore the interpretation is not the same, but it happens too often. And I'm aware of the theory de l'intérêt ou de l'acte clair, but unfortunately, too often jurisdictions thinks the act is clear and is not according to us, and not even according to the Court of Justice. Thank you.
May I make a few comments? Just a comment in response to Anais. You said the development of the case law should not prevent the Commission bringing forward legislation. I 100% agree with you, but I haven't said this. I didn't say that the Commission is prevented by the development of the case law in bringing. I said the Commission does not need to bring legislation or legislative proposal only in order to see it mutilated by the co-legislators. And here I also not point only to the Council, I point to the European Parliament. Look at the past legislature and see how many times and what kind of rights the Parliament has brought into its position on environmental legislation only to drop those provisions and those rights in the trilogue. Look at that. Look at that. In order to assess the chances of mutilation of such a legislative proposal. So why should I go through the woods where the big bad wolf lives when I can bypass the wood and use the nice opportunities offered by the case law of the European Court of Justice? Of course, you will apologize me, and I hope no MEP listens to this and no member state. I'm just using metaphors, and my metaphors do not entirely correspond with what happens in the real life. A comment about the problem of the validity of acts without implementing measures. The environmental NGOs can ask for the administrative review of those acts, which would be considered as being illegal under environmental legislation. And if the Commission does not see a reason of illegality and does not withdraw the act following the administrative review, the NGOs could go in the Court of Justice of the European Union against that decision of the Commission. But I think those acts who would be tainted by invalidity, even if they don't require implementing measures, they will still have to be applied in practice on the ground. And there are opportunities also to challenge them in front of the national courts, even in the absence of implementing measures, and to raise the problem of the validity in the front of the national court, which is obliged then to send the question to the Court of Justice of the European Union. So the second question, I haven't really, I saw it in writing as well, but I didn't grasp it. I only saw that the person who has asked the question has even made a bibliographical reference to a forthcoming publication by Routledge of his own book, which will no doubt be very interesting to read, but I don't know it. I haven't. I didn't have the privilege to read it, but I didn't grasp the question.
Well, we'll leave it, I think, because we're out of time. But I want to.
Adam,
Yes.
may I just a
course.
quick, really quick question, and it's actually also an update. I agree. I agree, and I know some of the access to justice provisions that had been proposed by the European Commission and some of the proposals haven't taken on board by the European Parliament and by the Council. But very importantly, in the EU climate law, the European Parliament just voted such provisions. So there is an access to justice provision in the EU climate law voted by the European Parliament. So let's try to keep it. Let's try and ensure that the three institutions support it during the trialogues, and that we start integrating more of these into the other legislations that I'm sure will be adopted under the EU Green Deal. Thank you.
If I may provide an answer in 30 seconds to Anais, who likes to be very provocative, I would say, let's look at the climate law at the end of the legislative procedure. I know how the sausages are made, speaking about that provision on access to justice. Let's look at the end of the legislative process. But I don't want to create un procès d'intention. I look forward with optimism, as I did also in the past to other legislative procedures. But I was disappointed to see that some things were just tactical moves. Mm-hmm. So one needs to learn. I'm not necessarily a critic, but one needs to learn to what happens to us. Thank you. Need to learn from experience, huh?
Let's keep hoping. We believe in the Green Deal.
Absolutely.
I will.
You join us.
I will cut you off there, but I appreciate this this debate, which is on vital issues, and I think is good-natured because we share so many values, and that's not always the case with some of the debates that go on in the today in general, but particularly in relation to these environmental issues. Just a few points. One is that we will make sure that the entirety of Aurel's keynote speech is available to you, either by incorporating it into the recording of this whole session or by separately sending the link. There was an interesting question that came up that we won't have time for, but it was about strategic litigation that has so far targeted the climate crisis, but not so much the biodiversity crisis. I hope that the questioner and others will be attending tomorrow afternoon's session, where there will be some live examples of strategic litigation for the environment. And that point about the biodiversity crisis is very dear to my heart. So I hope that the issue will come up again. And the last point is to thank our speakers who made this a very rich and rewarding session. Also to thank the various people, including ClientEarth colleagues who were busily answering questions behind the scenes in the chat, which I think was also very rewarding. And we've got lots of links to very interesting pieces of jurisprudence that were cited, for example. And lastly, to thank all of you, the participants, for being patient with us with some of the technological difficulties, but also for your very interesting questions and contributions in the chat. We are now going to take a break until 12:30, so that will give you 1 hour and 20 minutes maybe to have a bite to eat. And then we will come back for a very interesting session that follows on nicely because it deals with what goes on at the national level in 4 selected member states. Thank you very much, everyone.
Thank you very much. Bye-bye. Thank you, Anne.
Thank you very much for this very interesting discussion.